Hi, everyone. We are back again, and today we are going to talk about medical law and ethics. This will be part of the administrative playlist, just so you know. All right, so medical law and ethics. Let's talk a little bit about that. If you have not already, and you really enjoy what I do here, please, if you would, give me a like and subscribe to the channel. It goes a long way, really means a lot to me, and helps me to continue to do what I'm doing. All right, so let's talk about law versus ethics. We hear medical law and ethics put together a lot. And some people use those terms synonymously. They're really not. They're close, but they're not. So here's the difference. The difference is law is a rule that's been established, usually by a government, and enforced by an authority or a governing body. So the authority, would be the police department, be it city, county, state, um, a attorney general's office, any authoritative body that has been tasked with enforcing laws. Ethics, on the other hand, is a little more of a loose term. It's just as important, no doubt, but it's the general principles. It's the difference between right and wrong. It doesn't necessarily mean it's a law. Okay. A good example would be just to kind of emphasize the difference. So I'm not going to get arrested if I am rude to someone if I don't have manners. Okay. Nobody's going to arrest me over not having manners. It's not against the law. But in the business world or as a medical assistant, I don't want to be rude to my patients. I don't want to not have manners. So there's where my ethics come in. Okay, so that's the difference. Then we talk about rights a lot. And a right is basically, just by definition, a claim that one would expect to be honored. Okay. We have natural rights, primarily, the right to life, the right to privacy. That becomes a big, big thing in the medical field because we hold so much of our patients' very personal information. So they have the right to, make sure that we are keeping all of that private. The right to autonomy, to be able to make our own decisions for things. And of course, when I say we, or our, I am talking about, adults, over the age of 18, sound mind. There are limits, with autonomy, but it's basically the right to make our own decisions. And then the right to sustaining life. Okay. Along with rights comes duties. And duties for health professionals are to do no harm. And the kind of technical term for that is non-malfeasance, because malfeasance, and if you go back to your medical terminology, mal means bad. So malfeasance means doing something like knowingly wrong. So non-malfeasance would be to do no harm, to do the best job possible. We're all trained differently. We all have different backgrounds, so we just need to do the best possible job for what it is we are trained to do. This is called beneficence. To adhere to reasonable expectations is called fidelity, and reasonable expectations kind of goes along with the doing the best possible job. Is it reasonable for me as a medical assistant? Is a reasonable expectation for me by a patient that I could do brain surgery on them? No, of course I can't. Okay. Could a neurosurgeon? Absolutely. So they would be adhering to their reasonable expectations as I would adhere to mine. Being truthful, called veracity. You never want to lie to your patients. You should never lie to anybody, as far as I'm concerned. But um, we don't lie to our patients. We don't tell them that everything's going to be okay when it may or may not be. We don't tell them that something's not going to hurt because it might. I've always said, downplay it if you can. Try to, you know, comfort your patient as best you can, but at the same time without lying to them. And then treat each person fairly. This is called justice. Every patient that walks through our doors should be treated fairly, regardless of their ability to pay for their services, whether or not they have good insurance or poor insurance, um, whether or not they look a certain way, if they are someone that maybe we don't agree with necessarily for in our own personal lives, all of that goes out the door when they become our patients. A patient is a patient, regardless of their gender, their age, the color of their skin, their, like I said, their ability to pay or whether or not they have insurance. Um, all of that goes out the door. They are the person that we are tasked with caring for and with helping. And that is all that matters. Okay. And that is called justice. All right, we have private law versus public law. And the difference there is basically criminal law is public law, and criminal law is any act that threatens like society as a whole. Okay. Where civil law is more what we term private law, and these are usually disputes or disagreements between either individuals or groups. Okay. This usually involves some kind of damage. And by damage, that's usually some kind of like monetary damage or something like that. It can be physical damage too, but generally it's not intentional. Okay, so that's the difference between public law versus private law. Criminal law, so to kind of explain further, criminal law or public law, um, will always involve a crime, obviously, and that is malfeasance, as I had explained a minute ago. Um, a crime is an unlawful act because we talked about laws, right? There are two different types of crime kind of subcategories. You have felonies, which are very serious crimes usually, and usually carry some type of strict consequence, like imprisonment or something like that. Where a misdemeanor is a less serious crime and usually carries then a less strict consequence, like a fine or something. Um, so that is criminal law. There are non-violent crimes, and these are probably the most common criminal law related issues when we talk about healthcare. So crimes that are like related to the death of a patient. Okay. Serious, however, non-violent. Um, if death was caused unintentionally, that could be considered manslaughter if someone decided to take it that far. Sometimes criminal negligence. In most states, physician-assisted suicide is not legal. So anything that would be considered physician-assisted suicide or any type of assisted suicide would also be a non-violent crime. Other nonviolent crimes are financial crimes, and quite honestly, these are the ones you see the most in the healthcare field anyway. Um, Larceny, stealing, embezzlement is taking money from either an employer or a client or a patient. And then fraud is, of course, deliberately deceiving for gain. And when I say that you see this most often in healthcare, I mean, you see this as the most frequently seen nonviolent crime in healthcare. It's not that healthcare is riddled with financial crimes. It's not, but you do see, as far as you don't see so much, death and stuff like that as you see financial issues. Probably fraud being the number one, where you have, unscrupulous billing practices and things like that. So all money related usually. Civil law are probably the most common non-criminal disputes that we see in healthcare. And they kind of wide range of issues. Breach of contract is one of them, and that's basically just failing to meet the terms of a contract. And a contract really, the physician-patient relationship is considered a contract. Torts are defined as any injury or wrongdoing against a person or property. And there can be an intentional tort or an unintentional tort. Intentional meaning, of course, that the person who is committing it knowingly understands the consequences that are involved, but they do it anyway. And unintentional would be mistakenly causing some type of injury or damage or something to that effect. Misfeasance, so we talked about malfeasance, right? Misfeasance is something that would result in injury or damage that is just an act performed improperly that causes that damage. I always look at it as as being like mistake. That's how I remember that one. So misfeasance is kind of a, oops, I didn't mean to, but I messed up, and now we have injury caused or damage. Nonfeasance is literally that. It's non, like it, something that should have been done but wasn't, causing or resulting in some type of injury or damage. So, a good example of that would be patient, a female patient, let's say, comes in saying that they feel like they've felt maybe a lump in their breast, and the provider goes, it's probably fine, I wouldn't worry about it, and doesn't refer them out for a mammogram or an ultrasound or any kind of testing to see what it is. And several months later, they wind up with breast cancer. That would be nonfeasance, and that would fall under civil law because what the provider should have done, they didn't. Okay, so physician rights and duties. We already talked about rights. We talked about duties. So physicians have rights and duties, as do patients. The physician rights and duties. So as far as a duty goes, physician or provider, we see a lot that says physician, but really it's provider because we have the mid-level providers that are so common now, like, physician assistants and nurse practitioners. But physician rights and duties or provider rights and duties, they are responsible for the patient unless the patient's been formally dismissed, which we'll talk about here in a minute. But they are responsible for the patient, and they are to treat them to the best of their ability. They do have the right to accept or decline to treat a patient. The only place that is not an option is in an emergency department. They can choose to limit their medical practice to any size or specialty, and they also have the right to choose to practice at any location and follow any type of schedule. There's nothing saying that a doctor's office has to be this and has to be open from this time to this time and has to be in, this city. There's nothing saying that. They have the right to choose all of that. A patient's right and duties include the following. So patient duties is that they agree to keeping their appointment, providing accurate information, following instructions, paying for their services. Those are their duties. Their rights are they do have the right to refuse treatment. They have the right to receive information about the procedures and treatments they are proposed to receive. They have the right to select a provider, any provider they want. They have the right to expect confidentiality, and they have the right to be treated with respect. Now, these agreed to list right here is probably all of those actually are reasons why a patient would get dismissed. And I talked about formal dismissal in the last slide. We will talk about that again, trust me. And here we go. Terminating a provider and patient relationship. So dismissal of a patient, we used to call it firing a patient. The patient has to be notified in writing, and the letter has to be sent using certified mail with a return receipt requested. So the little green, I don't know if you've ever seen these or if you've ever used them, but it has to be a paper letter. The little green sticker has to go on the back where they have to sign for it. And then that is then sent back to the practice just to prove that they actually received the letter. The letter must state the reason why they're being dismissed. And like I said in the previous slide, missing appointments regularly, not paying for services. And that doesn't mean like once or twice. That means like habitually, not complying with the provider's instructions habitually. And it's not like, patient misses a, no call, no shows on an appointment like once and we go, that's it, you're done. No, this has to be a habitual thing. Um, but it does have to state the reason. The letter has to provide the information on how the patient can retrieve their medical records. And generally, they give them a time period in which to find another provider. It's usually 30 days. So they have 30 days to still retain the office as their provider to refill prescriptions or whatever they need to do. And then all the copies of any correspondence back and forth between the office and this patient then needs to be retained in the patient's records. Failure to do any of this can result in a lawsuit against the practice because that would then constitute what they call abandonment. If we just said we're not going to see this person anymore and not let them know that, not tell them why, not give them time, any of that, that's called abandonment, when you just kind of dismiss your duties to your patient and don't, care for them. So very kind of strict little legal aspect that you have to go through in order to terminate a relationship with a patient. All right, on to informed consent. So informed consent is literally that. It is consent that is given by the patient to the provider after they have been informed of all of the information, the options, everything having to do with whatever it is they're giving consent to. It can be expressed or implied. Now, what that means is expressed could be verbal or written, or implied, meaning, for instance, if I came up to a patient and said, "Hi, I'm your medical assistant, and I am going to need to draw some blood on you today." And the patient goes, "Oh, okay, great," and starts rolling up their shirt sleeve. That's implied consent. That means they're saying, "Okay, go ahead." Okay, so that's what implied consent is. Expressed consent is, like I said, verbal or written. Um, and verbal or written depends on what exactly they're giving consent for. There are some things that absolutely have to be signed, like surgical procedures and things like that. What informed consent provides information on or for is the potential risks of the procedure, any common side effects of the procedure, probable outcomes or results if the procedure is not performed, or even the probable outcomes of the procedure being performed. It's kind of just a big picture of what the patient can expect, to give them enough information to let them go, okay, let me think this over, and then either say yes or no. It is very important that the patient understands what we have told them. So we do have to confirm understanding. Um, Consent has to be given for release of information in most cases. But a patient for that, well, any kind of consent really, can withdraw consent at any time that they choose as well. All right, medical malpractice. Hopefully you go through your entire career and never have to deal with any of this. Um, but you may, unfortunately. Medical malpractice is often referred to or can be synonymous with negligence. There are what they call the 4 Ds of negligence that you have to prove as a patient. Um, these are required to prove malpractice actually took place. So any lawyer, any malpractice lawyer will tell you you have to have these in place before the lawsuit's even viable. And those are duty, derelict, direct cause, and damage. So duty means they have to establish that the professional, be it a doctor, nurse practitioner, PA, whatever, has a duty to the patient. So what that means is you have to prove that there was a patient-provider relationship established. A patient can't just willy-nilly go pick a provider out of a list and go, I'm going to sue them. Okay, you have to prove that. Um, you also have to prove derelict. Derelict means that the professional, whoever it was, failed to meet that duty. Okay, so you establish that the patient or the patient establishes that they had a patient provider relationship with Dr. X. And now what needs to be proven next is that Dr. X failed to meet their responsibilities to the patient. Once you've proven that, you need to prove the patient needs to prove, sorry, having a hard time talking today, direct cause, meaning that the derelict, the failure to meet the duty, was the direct cause of the injury. Okay, so you can't have a patient that came in for, I don't know, pain in their foot, and the provider ordered some x-rays, looked at the x-rays and said, this looks like you sprained it. We'll go ahead and just, put an ace bandage on that and, give it a little ice and everything. You should be fine. And then the patient goes out, I don't know, 3 or 4 days later and busts their foot riding a scooter or something, and then comes back and says, my foot's broken and you said it was only sprained. Okay, that would be wrong. So you have to prove that the cause of the injury was because the provider did not provide their response or meet their responsibility. And then damage, you have to prove the damage even exists. In the case of the foot, you got to have the x-rays that show. Okay. So those are the 4 Ds of negligence. Those are what have to be in place in order to prove malpractice in a malpractice suit. There is a Latin term called res ipsa loquitur. Probably not saying that right, but that's how I've said it my whole life. It's a doctrine meaning, loosely translated, that the thing speaks for itself. And they use this if there's no direct knowledge by the patient of how the injury occurred. Um, so basically, they're pretty sure that the duty, the derelict, the direct cause, and the damage are all there, but they don't know just how that happened. So they use this doctrine of res ipsa loquitur. So there you go. Okay, and I think this is probably one of the last things I'm going to talk to you about is, oh no, there's a couple more things, I apologize, is HIPAA, which stands for the Health Insurance Portability and Accountability Act of 1996. I know that because I was just starting medical assisting school when they were going through all of this. Um, Health insurance availability and coverage is part of um, HIPAA, and a lot of people think HIPAA is only for um, privacy. It is not. Health insurance availability and coverage is part of it, meaning that group health plans can't exclude individuals that have like certain diagnoses, pre-existing conditions, so to speak, um, genetic issues, things like that. And then the bigger part of it is the privacy rule, which patients have to be given a written notice of privacy. So you've all seen a HIPAA notice, I am sure. Um, Patients have the right to access their medical records. The medical facility has to prevent unauthorized access to the patient's information, so keep it nice and safe. Employees have to receive HIPAA training, so any employee that works in the medical field that would have access to or be around medical information, medical records, private health information of their patients have to receive HIPAA training. And then the standards have to be maintained for the security of all the patient's records, whether they are paper records or electronic records. So that's kind of just a quick overview of HIPAA. Lastly, we talk about state and national regulations for medical assistance. This is something that varies quite widely. Not all states have regulations for the state. My state does, and I know of maybe one, possibly two that have certain caveats for medical assistance within the state. My state requires state certification as well as national certification. We are the only state that I am aware of in the United States that is that um, regulatory with MAs. Many areas or many practices require that a MA have a national certification. Some places don't. So it really just depends on where you go. And if you are not sure if you're moving to a new area or something like that, you can look it up. You can get on that state's, usually their Department of Health website, or even just type in, you know, certification requirements for the state of fill in the blank. Um, you can also do that for scope of practice. Every state is slightly different on their scope of practice for MAs. So you would want to check that out. And you can, again, you can Google just scope of practice for medical assistance for the state of fill in the blank. And it should give you some choices of websites. I know ours takes us here directly to the Department of Health. And then they've got what they call the RCW, which is, the legal mumbo jumbo that has a list of what MAs can do and what we can't do. Not all states are quite that specific. Some will just say basically if the doctor's okay with it, then you're fine. But please do check that out and be aware of it if you are not already, or if you're moving to a new area. Certification requirements again vary from state to state, even sometimes office to office. And there are kind of what I call the big four of national medical assistant certification bodies. And those are what I have here on the screen. You have the double AMA, which is the American Association of Medical Assistants. They are the only one in this list that only certifies medical assistants. And from them, you would obtain the CMA, which is the Certified Medical Assistant Certification. The AMT, the American Medical Technologists, certified medical assistants, and other allied health professionals. And from them you get the RMA, which is Registered Medical Assistant. The NHA is the National Health Career Association, and from them they also certify others. From them you would get the Certified Clinical Medical Assistant certification. And then the NCCT, which is the National Center for Competency Testing. You would get the National Certified Medical Assistant, NCMA, certification from them. Now, here is the big question I always get from students is, which one's better? The answer is none. They're all the same. The only reason they're different is they are under the body of different companies, basically, or under the control of different bodies. The reason the credentialing is different, the letters, is because they couldn't all be the same, or else you wouldn't know where they came from. That's really the only difference. A CMA, an RMA, a CCMA, and an NCMA are all the same. And the certification exams are basically all the same too. I've taken 3 of those in my life. And they're all the same. So there's not one that's better than others. There are different eligibility routes and requirements for each of them, which you can look on their websites to find those out. But for the most part, it really doesn't matter which one you take. There's going to be some that are more prevalent in certain areas than others, but again, it really doesn't matter. So I hope that makes sense. If you ever have questions on that, please, drop in the comments. I'll be sure to get back to you on it. All right, so that is all I have for you today. Thank you so much for watching, and I will see you the next time. Take care.